Rhodes Show. Turn up your mind.
Gay rights is once again taking center stage at the Supreme Court. At the same time, Congress is poised to pass legislation ensuring federal benefits for same-sex couples,
as amended, has passed,
and requiring states to recognize gay marriage. But while Congress is expanding gay rights, some court watchers worry the conservative majority at the high court could roll back protections.
Compared to where we were as recently as 4, 5, 6 years ago, I think this is a court that's going to be far less sympathetic to gay rights issues.
This morning, the court will consider whether certain business owners can refuse to work with same-sex couples. It's a case being brought by Colorado website designer Lori Smith.
The state of Colorado is forcing me to create custom, unique artwork, expression, communicating and celebrating a different view of marriage, a view of marriage that goes against my deeply held beliefs.
Smith openly declares on her site that she is selective about the website she'll design, and she wants the Supreme Court to rule that she does not have to comply with a Colorado law that prohibits businesses from discriminating against same-sex couples. Her lawyer contends it comes down to Lori's role as a creator and free speech.
It's about whether the government can use the power of law to force Americans to say things that they don't believe.
But advocates on the other side argue if business owners like Smith are allowed to decide which customers they can refuse, any number of groups might ultimately be discriminated against.
You're going to have the Protestant baker who doesn't want to make the first communion cake. Do you want to have the school photographer who has their business, but they don't want to take pictures of certain kids?
Mary Bonato argued the case in 2015 that ultimately guaranteed the right to same-sex marriage nationwide. Right now, there are no cases pending before the Supreme Court that could put that right in peril, but nothing is stopping opponents from trying to get a similar case back before the court, where they could find a welcome audience. Justice Clarence Thomas, for one, urged the court, as part of the Dobbs decision overturning Roe v. Wade, to reconsider all of this court's substantive due process precedents, including the same-sex marriage decision.
So this is a case that could open the doors way wide for discrimination to once again be present, ever present in American life. Now, when you look at Donald Trump tweeting out ridiculous things that on their face are ridiculous, as I want to get rid of the Constitution, and everybody has a nice little belly laugh about it, and everybody asks, Republican Congress members and Republican senators, could you possibly support a man who wants to overturn the Constitution? They go, well, if he's a Republican, yeah, I guess I could. And everybody gets outraged. Let me tell you something. It doesn't happen like that, okay? The way that it happens is the way it's happening right now in the court, okay? Right now in the court, where the court decides that discrimination is a feature, not a bug, and that people need to have the right to discriminate against whoever they don't like, that they have a right to discriminate against, black people when they gerrymander the district. That's what the Harper case is. That's what the Moore v. Harper case is, that you don't have to include everybody in the district when you draw the map, and there would be no recourse. You can't go to court and say, wait a minute, that map was racially gerrymandered to take away the voice of black constituents, of black residents, or of Asian residents, or of Jewish residents, or of Hispanic residents, Latino residents. The court will not be allowed to hear that. The court will not be allowed to do anything with regard to voting rights, with regard to gerrymanders, with regard to how many polling places your district gets, or how many days of early voting, if any, you get in your state. The court would have no review opportunity or avenue. They would just shut the door to court review, and only your legislature could decide these things. Only your legislature could draw the maps. Only your legislature could decide how many polling places your district gets. Only your legislature would be allowed to, say how many early days of voting. Only your legislature could say how much ID you would actually have to produce. Do you have to produce a driver's license, or do you have to now produce a passport and a driver's license? And what happens to people who don't travel internationally and don't have a passport? Well, too bad. Your legislature just said only people who travel internationally, only people who have a passport are eligible to, vote, because we've just changed the voter ID laws to suppress voters. See, that's one thing. And then the other case is this one. This one's called 303 Creative LLC versus Elenis. And it isn't directly about the free exercise of religion, but it's definitely in the courtroom. This is about whether or not she has the right to discriminate against customers when she offers a public service to everybody. She wants to be able to have as much business as she can have, but she also wants to be able to discriminate after she has as much business as she, believes she wants and needs. She wants to be able to discriminate on the basis of race, on the basis of sex, on the basis of religion or sexual orientation. And this case is a discrimination case that would have far-reaching, authority too, because this is one of those cases that the Nazis would love, not because it deals with race, but because it deals with sex, because it deals with sexual orientation, because it deals with things like housing and employers and the whole 9 yards when you have a discrimination case like this. Meaning, if she prevails, and I don't know who she's prevailing against because nobody has sued her to create a wedding invitation for her that she denied. It didn't happen. It's just a made up case. But if she has the ability to discriminate against certain members of the public in Colorado, which is, again, this is Colorado again, Masterpiece was too, and the reason why they do it in Colorado is because Colorado law actually forbids the discrimination against anybody on the basis of race or sex, religion, sexual orientation. So they bring these cases in Colorado to challenge the constitutionality of Colorado's law. And if she prevails, if the court rules that discrimination is it's a feature of American life, not a bug, that it's not bad, that we don't mind it, that it's okay, that people get to do this. Do you understand that that means that if you're an interracial couple, that maybe this landlord doesn't have to rent to you too? Or do you understand that it means that if you are an employer and you want an all-male workplace, you can now do that? Or if you want an all-female workplace, you can now do that? Or if you want a workplace of men and women, but you want men and women not to fraternize, you can do that too. You can keep the men separate from the women. Do you understand what this kind of stuff is, where you don't have to hire any gay person if you don't want to? You don't have to hire any Hispanic person if you don't want to. You don't have to hire any transgender person if you don't want to. That, any landlord with religious objections to interracial marriage can prevail. That is what the court is doing here. That is why they create these cases, so that they can make discrimination very American again. This is what MAGA was all about. And this Supreme Court is sitting there perched upon their elite thrones, ready to do that, ready to make discrimination a thing again.